This is Daniel McCrane with McCrane Associates coming to you live on a Monday morning, start of a new week. And small business owners choose to work with us to increase their profitability, expand their scalability, and solidify their legacy. And we guarantee our work in those areas. Well, today let's talk about what happens when you transfer your business, you're getting ready to transfer your business. And let's talk about some legal implications during the sale of a business. There are some potential misconceptions that come about during the sales process. And I just want to bring these to the table, to bring them to the front of your mind, to make sure that you don't step into these potential landmines as you're going through the transfer of a business. Now, whether you're a buyer or seller, there are some things in here for each of you when we're thinking about legal misconceptions and the protections. So one of the things where I see a lot of people, it seems like they're not really doing what they should be doing. Everybody talks about due diligence, and quite honestly, when I'm involved kind of in the inside of a transaction, watching a business transfer from seller to buyer. Um, Quite frankly, I don't see a lot of due diligence going on. Now, maybe it's happening behind the scenes. Even for me, being inside the transaction, maybe each of the buyer, the seller, each have their own lawyer who's doing some legal due diligence. But this is something that you really want to make sure that you are paying attention to do that legal due diligence. Most people just treat it as a formality. They just say 30 days, 60 days due diligence, and then 60 days passes, whatever the time frame is, and okay, we're ready to close. Okay, well, what did you uncover during that time period? Did you actually do any due diligence? So some people just treat it as a formality. They just put a waiting period on the transaction before closing, but it really is something that you should be involved in, and actually take some action on and do something about. You want to do some things. So perhaps if you're the buyer, for example, you want to make sure that you're looking at contracts that the seller has within the business. You want to look at potential compliance issues, maybe with the state, maybe like unemployment insurance, sales tax, if there are immigration issues among the employees that you need to be aware of, some different things like that, intellectual property, trademarks, patents, those kinds of things, all those kinds of legal matters. Those are things that you want to look into when you're doing your legal due diligence. From the seller perspective, you'll want to do the same thing on the buyer. You want to make sure that you're looking at the contract that's being presented to you. You want to find out what kind of issues the buyer has had in the past and whether their legal problems will expose you to their legal liabilities. You'll want to be aware of these kinds of things and watch out for those. Another misconception is that the transaction is contained entirely to the contract itself. Well, sometimes there could be some legal issues that could extend outside the contract, or you may go into the transaction thinking the contract is completely ironclad. It's tight, and everything that is inside the contract is exactly the way that things are going to be. But unless you have a lawyer take a look at that contract, you may not be aware of loopholes or gray areas or anything that could cause some issues with interpreting that contract in the future if questions should ever come up. That's something you'll want to take a look at. There are other misconceptions that take place around letters of intent. So when a letter of intent gets passed to the seller from the buyer, a lot of times letters of intent are intended to be non-binding. So if the seller accepts that letter of intent, it sort of means they're locked in. They have to work with this buyer until the buyer decides they want to be formal and move forward, or step away from the transaction. But it's not binding on the buyer to actually follow through the transaction. However, because of that non binding aspect of the letter of intent, Some people think that the entire letter of intent is non binding, which is not actually true. There are parts of the letter of intent that will continue to carry forward even after the buyer steps away and says, I'm not interested. Such things like any exclusivity clauses, confidentiality agreements. Is a big one there. Any sort of fees or anything that have been negotiated that were part of the letter of intent, those kinds of things are actually binding in that letter of intent. So there are quite a few things that you need to be aware of and take a look at. I always recommend that you get your lawyer involved when a transaction is underway. At least have a conversation with the lawyer and find out if there are any areas of liability you may be exposing yourself to unintentionally. So, got to stop here. With that, everyone, have a great day.